By now, a lot of inventors already know that ChatGPT can be useful. The issue is that ChatGPT often gives answers about patents that sound smart, clean, and confident. And that's where inventors get into trouble. Because in patent law, a confident answer is not the same as a correct answer. So in this video, I want to show you what ChatGPT tends to get wrong about patents. Because when the issue is legal strategy, experienced judgment matters more than polished output. The problem is that it often answers patent questions in a way that feels more definitive than the law actually is. And that's a dangerous mismatch, because patents live in a world of nuance. Nuance is where a judgment call needs to be made. A small wording difference can matter. A timing issue can matter. A public disclosure can matter. A country difference can matter. A claim scope decision can matter. The exact way an invention was developed can matter. So when someone asks ChatGPT something like, "Can I patent this? Am I safe if I disclosed it already? Does this count as prior art? Is this patentable in Europe too? Can AI be listed as an inventor? Is this broad enough to protect me?" The answer often needs context that isn't given. The first thing ChatGPT gets wrong about patents is legal nuance. It often gives broad answers to narrow questions. For example, someone might ask, "Can I still file if I already talked about my invention?" That sounds like a simple question. It isn't. The real answer depends on what exactly was disclosed, when was it disclosed, to whom was it disclosed, whether there was a confidentiality agreement in place, what country you're talking about, and what rights may already have been affected. But ChatGPT may respond with something that sounds like, "You may still be able to file in some cases." That sounds helpful, but it may not be helpful enough to protect you. The next thing ChatGPT gets wrong a lot is jurisdiction. Inventors will ask a patent question as if patent law is just one universal system, but it isn't. So even when ChatGPT gives a technically reasonable answer, it may quietly assume US rules, or it may blend different jurisdiction rules together in a way that creates confusion. And that matters a lot, because a public disclosure issue in the United States may not play the same way in Europe. Another place ChatGPT often misleads people is patent eligibility. This is especially common with software, business method patents, and AI-related inventions. Someone may ask, "Can I patent my app? Can I patent this workflow? Can I patent an AI-based tool? Can I patent a business process?" And ChatGPT may produce an answer that sounds encouraging but shallow. The real issue is that eligibility is not just about whether the idea feels innovative. It's about how the invention is framed legally. Here's a reality check. Every patent still has to satisfy novelty, non-obviousness, and enablement. And human contribution has to be documented clearly when AI tools were involved. Now let's get into a mistake that ChatGPT makes that inventors almost never see coming. Claim scope. This one matters because it's invisible to beginners. The real question is, how much does the patent actually cover? And that comes down to claim scope. But claim scope is where the real leverage lives. A patent can exist, your patent can be granted, and still be too narrow, too easy to design around, too vague in the wrong places, unsupported where it matters, or commercially weak, even if it's technically granted. A polished patent application can still leave you with weak protection if the legal architecture is wrong. And inventors who don't understand claim scope are often undervaluing what a patent filing actually gets them. This is another major blind spot. ChatGPT tends to be treated by users like it's a trusted or neutral thinking partner. But patent law cares deeply about disclosure, confidentiality, and timing. And inventors often don't realize how casually they're creating risk for themselves. The real issue is not that AI is evil, but that inventors can damage themselves through confidentiality, disclosure, and timing mistakes. This matters because ChatGPT will often answer invention questions as though the main risk is getting the answer wrong. This may be the biggest one of all. ChatGPT often makes inventors feel like they understand more than they do. Not because they're foolish, but because the tool is good at creating the feeling of clarity. And clarity can be seductive. And that can make someone feel informed enough to move forward. But one of the strongest themes here is that people keep collapsing separate questions into one big yes. In this ownership framework, founders confuse use, own, protect, and defend as if they're interchangeable when they're not. If you've watched the first 3 videos in this series, here's the bigger picture. ChatGPT can help you organize, it can help you research, It can help you generate drafting language. But once you start relying on it for actual legal conclusions, that's where the risk goes up. Because patents are full of nuance. So what does ChatGPT get wrong about patents? Usually not everything. And that's what makes it dangerous. It often gets enough right to sound credible while missing the nuance that matters most. And in patent law, missing the nuance is how smart inventors make expensive mistakes. But if you want to protect something valuable, don't confuse fast answers with legal judgment. Use Goldstein intellectual property to think legally. If you found this helpful, subscribe. And if you want real guidance before you rely on an AI answer for something this important to you, connect with me.